CF Press here outside the Old Bailey, and we have Dr. Deepa Driver, who's been at the public gallery for the past few days, if not the whole case, most of the time, and she's going to give us an update from her perspective as someone who is a campaigner for the rights of freedom of speech and the right to publish the truth. Deepa.
Thanks, Chair. Thank you for inviting me. Some key thoughts in relation to yesterday and today were that, they were intending 3 days of evidence from psychiatric experts and medical evidence. My impression of things, I'll start with the access issues outside. The access issue still continues. So the 40 NGOs whose access was revoked at the start of the hearing after being granted access are still competing with the public for 2 spaces in the mornings to enter the Old Bailey. This is given that there are, between the 2 courtrooms that we sit in, there are 66 seats in the public gallery. And this is, of course, in addition to the 44 seats in each room, which are devoted to journalists and political observers, etc. So 2 seats out of 66 does seem an area of concern. The next is how the fact that 3 seats are currently reserved for VIPs by the judge. Those VIPs so far have never turned up, and these seats are sometimes released later in the day, typically 3 further seats. We've also had, I've had concerns from the start of this process in relation to equality of arms, the defence, because of the way in which the judge has decided to agree the proceedings, have half an hour to present their defence witnesses' position, and then the prosecution usually examines for 2 hours. Yesterday, with Professor Kopelman, the prosecution examined for over 4 hours. So, for me, both as a legal observer but also as a lay observer, I'm concerned about the balance between hearing what the prosecution has to say and the defence has to say. And the judge has made the point that she is receiving all the submissions in full from the prosecution and defence, but I believe that in the interest of open justice, in addition to the access issues, this issue of being able to hear and understand what is going on is very important, and the fact that us in the public gallery are in a separate room watching a TV monitor which is 1 metre across at the far end of the room, and therefore little able to distinguish any of the facial features or what is really going on in the room. We occasionally, at my request, we now have twice a day, we have a glimpse of Mr. Assange in the dock, and we can make out a hazy outline of somebody with light hair and a face mask, and we know this to be Mr. Assange. So that's the open justice issue. We're then moving to the actual discussion within the court, and as a lay or a legal observer, I find it very disturbing the way in which the prosecution has gone after the expert witnesses, and their position seems to be one of 5 things. 1, you're not an expert, and they said this to Professor Kopelman yesterday, and he's, I believe, the country's premier forensic psychiatrist. And they made that implication very clear. In fact, I was shocked to hear the prosecution refer to Professor Niels Melzer, who's the UN Special Rapporteur on Torture, as Mr. Niels Melzer, and say in exact words that his report was palpably nonsense. And this suggests to me, again, as an outsider, suggests some kind of disrespect for international law and our duties and obligations under that, given that the judge, who has interrupted on several occasions so far I can see, in order to put forth objections or clarifications on behalf of the prosecution, allowed this to go unchallenged. Within the so that was the first point in terms of your expertise is not valid. The second point, which they tend to use, is you're not independent, you have some prior connection to Julian Assange, which they've used with a number of witnesses, and Professor Kopelman, obviously as a senior and experienced medical legal professional, has been able to answer those questions exceedingly well. They then go on to saying that the information that he relies upon is inaccurate or incomplete or incorrect, and therefore his opinions are invalid. And what I found very disturbing is that many of the, because of the way in which the timetable is arranged, and for a variety of other reasons, including the fact that that second superseding indictment arrived so late, it certainly appears that in Professor Koppelman's case, for example, he was referred to a document which had been sent to him yesterday morning, which obviously he did not have access to in the court, because, and then he had to opine on something that he hadn't seen, and he started at 10 in the morning. So to me, this doesn't seem like they're making the best use of the expertise of the witnesses if the witnesses cannot even read the information that they're supposed to opine on. Then you get to this situation where the technique of the prosecution, which I find quite, how do I say, troubling, is repeatedly quoting selective sections, and this is not repeatedly once, twice, thrice. It went on for over, I would say, about 45 minutes to an hour. I don't have a timer which I can use because we are relieved of our phone even drinking water before we go in. So we have no way of checking. Well, I could bring a watch and I could check the time, and I keep trying to remember to do that, but sometimes I forget. So repeatedly asking him questions from selective quotes, but also saying things like, can you remember the specific 8 criteria that they used? And Professor Koppelman, for example, explained the thinking behind the 8 criteria, and at one stage he quite rightly pointed out to Mr. Lewis that Mr. Lewis was not a psychiatrist and Mr. Lewis was a lawyer, because Mr. Lewis was talking about some tests which Professor Koppelman obviously knew very much about, but was suggesting that a different test would be appropriate, and surely Professor Koppelman was wrong. And without even knowing what that test was, and they often ask for information. For example, the other day they asked Christian Grothoff if he could find a particular tweet for them in the 10 minutes that he had as a break, which was not a tweet by him, but some relation to evidence. And the way in which the case is packed does not allow people to even have a toilet break, if they are giving expert evidence, which is, when it goes on for several hours, can affect the quality of the testimony, I would suspect. But, I cannot judge that, but it does appear to me to be something I would be concerned about. And I can't remember how many have gone through that, but the general approach seems to be one of browbeating, and the prosecution approach seems to be very belligerent. And I find that that can be a prosecutorial style, but it is at odds with delivering justice in a case where you insist, for example, as the prosecution has done, that no torture has occurred in Guantanamo and they are not able to admit to it, or agree to the fact that there is certain things which are factual, which obviously the US doesn't want to admit to because then there would be liability, but we know in the public domain. Sitting outside, I find it very difficult, and perhaps this is a sign of they will say this is a sign of their capability. The moral dilemmas that people face when saying, yesterday, for example, they tried several times, and this was the bit I found most disgusting and appalling, which is they tried to imply that the fact that Julian is highly intelligent and the fact that he has exceptional abilities in a certain area, for example, in setting up the principles behind WikiLeaks and the way in which it works, means that he cannot suffer from mental distress. Now, we know from Professor Niels Meltzer's report, which is, and from other evidence, that from medical evidence, which of course the US will contest, that Julian has been subject to prolonged psychological torture, and to then suggest that he cannot be depressed because he is highly intelligent, which was the insinuation which was being made, suggests a very outdated view of mental health, but also a very disrespectful view to people with, and there were also many comments made which suggest very great disrespect for people with neurodiversity. And in Julian's case, the way in which it was humiliating, torturous, I bet, for him to have to explore his such intimate details of his childhood, youth, and his medical conditions in front of so many members of the press. And I'm not saying that this doesn't happen in a normal case. I'm just suggesting that the prurient way in which some of this is discussed is disgusting and is unacceptable in this day and age. And we wouldn't tolerate other forms of discrimination, although we see it all the time. And I think we should condemn this as well. So, and then today we had the prosecution's witness, and I thought Edward Fitzgerald did a good job of being respectful while challenging some of the opinions of the witness, who took a position that although they had never visited ADX Colorado or the maximum security detention facility, they could make certain, they offered certain interpretations of whether risk would be reduced or heightened. And I would hope the judge, who indeed did intervene a couple of times to make the prosecution's case for them, I thought, but I don't know whether that's how it would be perceived by an expert, seemed to note what they were saying. So that's my little roundup. I'm sorry, I'm just exhausted, because yesterday, as somebody who's absolutely despairing of the fact that our democracy is being undermined in plain sight, and although the national press are supposedly watching through this video, whatever, the quality of some of the mainstream articles being so prurient and vacuous suggests to me that we really need to up the standard of journalism and bring back the likes of Julian Assange, because the censorship that occurs through the complete disinterest in anything that is material of this particular type of press makes it even more important that we, the public, really use whistleblowers and direct sources to understand the crimes that corporations and governments commit in our name. Thank you.